Hi there. Sometimes employees just don't work out and you have to let them go. When you do that, you may want to seek a waiver and release agreement in exchange for a severance package, which could be even a relatively small payment of money or some extension of health insurance, for example. My name is Scott Horton, and I'm a labor and employment attorney, and I practice throughout the state of New York. But today I wanted to give you a quick overview of a relevant federal law that pertains to release agreement that you seek from employees. In particular, the Older Workers Benefit Protection Act applies specifically to employees who are 40 years of age or older and relates to their release of federal age discrimination claims. Now, if you are going to provide some sort of severance benefit to your employees and want to get a release in exchange for the severance, then you should make sure that your release complies with certain requirements from this specific federal law, especially if the employee is over the age of 40. Now, this law requires that releases include the following. First, the waiver must be in a written agreement between the employee and the employer. Moreover, the agreement has to be written in a manner calculated to be understood by the individual or the average individual eligible to participate in the release program. The release must specifically refer to rights or claims arising under the Age Discrimination in Employment Act, and the employee cannot waive any rights or claims that may arise after the release is signed. The employee must also receive something of value in exchange for the release of rights, and it must be something that the employer did not already have the obligation to pay to the employee, such as compensation due for work performed through the separation date. The employer also must advise the employee in writing to consult with an attorney before signing the release agreement. The employer must then give the employee at least 21 days to consider the release agreement, and the release agreement must give the employees a 7-day period even after signing the agreement in which it could be revoked. The agreement does not become enforceable before the end of that 7-day revocation period. Now, all of these terms are required in the case of even just one employee being offered a release agreement in exchange for severance. But if you are involved in some sort of group program, which could be a voluntary resignation incentive program or even an involuntary group layoff or reduction of force, then there are some additional requirements under the Older Workers Benefit Protection Act. In particular, the 21-day consideration period goes to 45 days, and you must provide additional written information, including a program description of any class, unit, or group of employees covered by the program and its eligibility factors and time limits, as well as a list of job titles and ages of all employees, both who are selected or eligible to participate in the program and those who are in similar organizational unit that were not selected for participation. Again, my name is Scott Horton, and if you need any assistance with any waiver and release agreements or severance agreements, I suggest that you speak to an experienced labor and employment attorney. I look forward to speaking with you again. Thank you.